Hello, everyone. Welcome. I am just going to give it 1 minute until everyone joins. Please feel free to grab a cup of coffee or a beverage, something to eat, and we'll get started shortly. I just want to make sure, Catherine, you're online. I see you.
Yeah, Maya, can you hear me
Awesome.
okay?
I can, yes.
Okay, great. Thank you.
Excellent. All right. So welcome, everyone. Thank you for joining our Lunch and Learn this month. For those who are not familiar with me, my name is Maya. I'm the Senior HR Consultant with H2R and your host for today. As you can see, you have been muted, but if you have questions, please use our chat or Q&A box, and you may ask questions at any time. We have two lovely speakers joining us today. Kicking things off with Catherine Phelps, Senior Associate at Philion, and she will be providing us with some legal updates as well as case law updates. And we have Reema joining us. She's a partner joining us from Deverell, Kalma and Associates, who will be speaking to us about maximizing the value of group benefits. So, welcome speakers. Catherine, take it away.
Thanks so much, Maya, and thank you for letting me join this group today. Before I get started, I just wanted to confirm, how long do I have?
You have about 30 minutes, I would say.
30 minutes?
Yeah.
Okay, perfect. Well, there's lots to cover, so I think that will work out well. So thank you so much, everyone. I'm really delighted to be here today. So my name is Catherine, and I'm a labor and employment lawyer with a law firm called Philion Weekly, and I know that we work very closely with our friends at H2R's, so thrilled to be here today. Just in terms of the overview for my presentation, I'm going to flag some of the key changes that will be implemented soon under the various iterations of the Working for Workers Act. And I'm also going to be discussing some temporary changes to EI rules that have been implemented in response to the US tariffs. And then I want to talk about a few interesting cases that have recently been released. In particular, I'm going to talk about two cases dealing with the enforceability of termination clauses in employment agreements, and an interesting case that just came out that deals with ending remote work arrangements. So we'll get started with the legislative update, and we're going to start with a review of the Working for Workers legislation. And so just by way of this, may be a refresher for some of you, in 2024, 3 new Working for Workers Acts were passed by the Ontario legislature, and each of these bills made amendments to the Employment Standards Act, the Occupational Health and Safety Act, and the Workplace Safety and Insurance Act, as well as establishing the new Digital Platform Workers' Rights Act. So this legislation has been keeping us employment lawyers really busy because it's been making various changes that employers have to comply with, and there's lots to keep up to date on. So these pieces of legislation received royal assent in 2024, but the effective dates of key changes will start over the next few months and continue into 2026. So if we move to the next slide, these are the various changes that are going to be implemented. And I don't want to spend too much time on this, but I wanted to flag some of the implementation dates that are coming up. So in particular, the new ESA long-term illness leave will become available to employees on June 19th. And you can see that there are a few more changes that will be implemented as of July 1st of this year. And perhaps the most important of these changes is that employers will be required to provide new information to employees where the workplace has more than 25 people. So this information must include the legal name of the employer and its operating or business name, complete contact information, and at least one contact name for the employer, as well as basic information about where the employee will first work, their expected hours of work, their starting compensation, and their pay period and pay day. So this is a great time right now to start reviewing your offer letters, reviewing the information that is sent out to new hires to make sure that you're including this information in order to be ESA compliant as of July 1st. And Maya, it looks like maybe we're having some technical issues. Should I just keep going or?
Yeah, can I just interrupt the presentation and
Sure.
see if anyone else is having issues seeing the slides this time?
I'm
I know
seeing the
Maria,
slide.
I can see, okay, so people can see. I would say then it's probably just individual. If you can log in
Okay.
and log out. Great, thank you. You can continue, Catherine. Thank
Okay.
you.
And I'm sure the slides will be distributed to everyone. So
Yes,
at the
we
end.
record the session as well, so that'll be
Perfect.
sent out to all the registrants.
Okay, that's great. So again, on this slide, there was just a summary going back to the last slide of some of these key changes. And I just wanted to flag that our firm published a really great article on January 10th summarizing the changes. So if you're interested in doing further reading, I would encourage you just to Google our firm, look up that article dated January 10th, and you can do some further reading there. So moving on to the long-term illness leave, I wanted to spend a little bit of time on this because this is going to be implemented as of June 19th. And the new long-term illness leave will be found in the new section 49.8 of the ESA. This legislative change provides employees who have been working for 13 consecutive weeks with a right to an unpaid leave where they will not be working due to a serious medical condition, and that's how it's defined in the legislation. The new language does not describe what is meant by a serious medical condition, but it does specifically state that it can include a condition that is episodic or chronic. And if we move on to the next slide, there's some more information here about this new leave of absence. In order to gain access to this unpaid leave, employees must provide a medical certificate from a doctor, registered nurse, psychologist, or other practitioner. And the other practitioner will be specified in the regulations. The leave may be up to 27 weeks in a 52-week period, and the 52-week period starts when the employee received the medical certificate or when the employee could not perform their duties due to their serious medical condition, whichever is earlier. Notably, the employee is only entitled to take the particular period of time off that is specified in their medical certificate. So, for example, if we have an employee who furnishes a medical note that indicates that they will return to work in 12 weeks, they are only entitled to a 12-week leave. However, the leave can be extended with a further medical certificate so long as the leave does not exceed 27 weeks in a 52-week period. In light of this leave entitlement, I just have sort of a few kind of takeaways for employers. So first of all, it's important for employers to recognize that employees will have a statutory right to this unpaid leave, and this is a job-protected leave. So this means that employees are entitled to return to their regular position and duties upon their return to work. We would recommend that you update workplace policies so that they comply with this new unpaid leave requirement. And I just wanted to flag that the implementation of this new leave doesn't impact an employer's human rights obligations. So employers still have a duty to accommodate employees under human rights law. So where an employee is ill for a period longer than 27 weeks, while their right to the unpaid leave under the ESA may end, it is possible that the employer will still have to recognize an unpaid leave of absence as a form of accommodation. So again, if you ever encounter this situation, I would recommend that you speak with your regular human resources consultant at H2R or your regular employment lawyer. So moving on, I wanted to touch on some of the temporary changes to EI rules that have been implemented in response to the US tariffs and the anticipated impact on the Canadian unemployment rate. So the federal government implemented a pilot project called the Employment Insurance Pilot Project 24. And under this project, there are 3 measures that were implemented as of April 9th, 2025. And these measures are intended to make EI benefits more accessible to Canadians who have lost their jobs as a result of the tariffs. So there's 3 The three key changes are highlighted on the screen. And the first is that for EI claims starting between April 6th and July 12th of this year, the government will artificially inflate certain regional unemployment rates to broaden the pool of workers who can access EI benefits. And this change means that employees will have to work fewer hours to qualify for EI, and they may be able to receive benefits for 4 weeks longer than they would have been able to in the normal course, and they may receive greater EI benefits. The second change is that the pilot project also eliminates the 1 week waiting period for accessing EI benefits from March 30th to October 11th of this year. And finally, the pilot project eliminates an employee's obligation to repay EI benefits if they have received a termination or severance payment from their employer. And the EI repayment obligation will be eliminated for the period of March 30th to October 11th of this year. So those are the legislative changes. I'm going to talk now about some case law updates. And we'll start with the Dufault and Ignace decision. And I understand that this decision, I think, was discussed in the last legal update, so I'm not going to spend too much time on it, but I think it's really important to review because it sets the stage for the next case that I'm going to talk about.
And Catherine, sorry to interrupt. We do have a question.
Okay,
I can read it out loud. I don't know if you see it on your end. It's in Q&A. Okay. So if an employee is currently on a medical leave of absence, will the long-term illness leave will be counted as on top of this? Thanks.
So if they're on a medical leave of absence, we would have to look at, like, if they're currently on a leave, I think is the question.
Yes, they're currently on a medical leave of absence.
That's a really good question. And I'm not sure if any guidance has been published about that, to be honest, Maya. So I might like to look into that, and I'd be happy to loop back with you later and we can respond to that question.
That would be great. Thank you.
Yeah, some of these things are like, there's sort of guidance that's continuously published as the updates are coming out. But that one in particular, I haven't heard anything about. So it's a great question. And if there's any more questions, just let me know because I can't see on my screen here. So turning back to the Dufault decision, in this case, the employee was employed as a youth engagement coordinator pursuant to a fixed term employment agreement for a term of 2 years. 2 months into the agreement, the employee's employment was terminated on a without cause basis, and the employee alleged that she was wrongfully dismissed because the termination provisions in her employment agreement contravened the Employment Standards Act. And the Ontario Superior Court of Justice upheld the claim on the basis that the language permitting the employer to terminate the employee's employment at its sole discretion and at any time contravened the ESA. And the court specifically cited that it could permit an employee's employment to be terminated while they are on a statutory leave of absence or in reprisal for attempting to exercise a right under the ESA. And for this reason, the court basically said this language is offside the ESA. It permits an employer to terminate an employee in circumstances where they're legally not allowed to, and therefore this language is unenforceable. So if we move on to the next slide, the Ontario Court of Appeal at the end of 2024 affirmed the lower court's decision and found that the termination clause in the agreement was unenforceable because the for-cause termination provision did not clearly limit the actions that met the willful misconduct standard. But the court declined to weigh in on the Superior Court's findings with respect to the without cause termination language, permitting the employer to terminate the employee in its sole discretion and at any time. And what this basically means is that the lower court's decision on the enforceability of the without cause termination clause is good law in Ontario. So this case really shook things up in employment law, and it's really significant because many existing employment contracts include language that permits the employer to terminate the employee in its sole discretion or at any time. And all of these employment agreements are now unenforceable because of the Dufaux decision. And this means that employees who have contracts with those language will be entitled to common law reasonable notice. So moving on to the Baker and Van Dolders decision. This was a more recent Superior Court decision that followed the ruling in Dufaux. So I want to spend a few minutes talking about it. So in this case, the employee's employment was once again terminated without cause. The employee challenged the enforceability of the termination provisions, alleging that the without cause provision was unenforceable because it allowed for termination at any time. And the Superior Court once again found that the at any time language was inconsistent with the ESA and was therefore unenforceable. It was also notable in this decision that the court specifically commented that an incorrect statement of ESA entitlements within a contract renders the provision unenforceable, even if the employer includes language committing to ESA compliance. So it's not good enough for the employer to say, notwithstanding the above, we will comply with the ESA. That's not good enough to save an unenforceable termination clause. At the next slide, we can see the termination for cause language. And the court also considered this language and whether it was enforceable. So as you can see on the slide here, the employer specifically spelled out the circumstances in which an employee could be terminated for just cause at common law. So it says, for example, if the employee engages in poor performance after having been notified in writing of the required standard, if they've engaged in dishonesty, and they were really descriptive here about what kind of conduct would permit an employee to be terminated for just cause. So if we move on to the next slide, the court found that the for cause termination language was also unenforceable because it failed to make clear that if there was just cause at common law, but that the willful misconduct standard under the ESA was not met, that the employee would still receive their ESA entitlements. And the court noted that many employees may not appreciate the distinction between just cause at common law and the willful misconduct standard under the ESA. And what the court said is basically an employee who was looking at that termination clause could think that they would be entitled to nothing if they engaged in any of the conduct that was on that list, even where that conduct did not meet the willful misconduct standard. And on this basis, the court once again said that this language is offside the ESA and therefore unenforceable. So I'm going to talk about some of the really important takeaways that these two cases have left us with. So first, it's really important to avoid language in termination clauses that permits the employer to terminate the employee in its sole discretion or at any time, as this will be found to violate the Employment Standards Act and therefore be unenforceable. So if you see any of that language in your contract, I would suggest that you immediately loop in an employment lawyer to review it and to revise the language to ensure that it's enforceable. If you do want to reference just cause at common law in the termination clause, it's important to make clear that the employee will only be disentitled from their minimum entitlements under the ESA if they engage in willful misconduct, disobedience, or willful neglect of duty that is not trivial and not condoned. And that is the specific language in the Employment Standards Act. So the courts have made very clear that the employer will be held to an exacting standard when it comes to termination clause language. And if the termination clause is not enforceable, the consequence of this is that the employee will be entitled to common law reasonable notice, which can be really significant. And this is why we would recommend that on a regular basis, sort of every 2 years, you send your employment agreement to your employment lawyer, have them review it, make sure that all the language is up to date so that you can avoid that really costly liability that comes with common law notice. And finally, I'm going to talk about the Bird and Welcome Home Children's Residence, Inc. decision. And I think this is a really interesting decision with an interesting and common set of facts, and it addresses an issue that I speak to clients a lot about, which is how do we get employees to return to work following the pandemic after they've gotten used to working from home? So this case sort of squarely addresses that issue and has some great takeaways. So the facts of this case are pretty straightforward and are set out on the slide. So in this case, the plaintiff was a manager at a children's residence. In 2020, she moved out of the country for her husband's military posting, and the employer verbally agreed to let her work remotely from Europe, but there was sort of no written contract allowing this arrangement. The plaintiff worked remotely from Europe for over a year with no changes to her pay or duties. In 2021, the employer hired a new manager in Canada, cut the plaintiff's hours, and reassigned her tasks. And she was told that she needed to return to Canada for in-person work or resign. So she was basically given an ultimatum that she needed to come back into the office. The employee sued for wrongful dismissal. So she alleged that the employer's ultimatum amounted to a constructive dismissal and was a fundamental alteration of the terms and conditions of her employment. And the Superior Court agreed with the employee in this case. So the court accepted the plaintiff's position that in the circumstances, she was constructively dismissed. The court found that providing the plaintiff with an ultimatum of returning to work in person or resigning amounted to a repudiation of the employment agreement and was, at law, a termination of employment. And the court's conclusion in this case was based on two key facts. So the court noted that the employee's ability to work remotely from Europe became an accepted part of her employment contract, and that the employer basically condoned the arrangement. The court also observed that the employer never established nor communicated a right to recall the plaintiff to in-person work. And the court noted that a fundamental term, such as the right to recall an employee from Europe to work in person in Ottawa, calls out for clear and timely notice to the employee, which was not provided in this case. So again, I think there's some really great takeaways and really sort of practical insights for employers who are trying to return employees to work in office who are currently working remotely. So first of all, I would really recommend that you have your employment agreements and workplace policies reviewed and updated to ensure that they have language permitting the employer to unilaterally change the employee's place of work. And what that will do is that will provide the employer with a contractual right to change the location of work so that when the employer invokes that right, it's not a constructive dismissal because it's a term of the contract. Sometimes where an employee is working remotely, some of our clients like to have remote work agreements in place. And those are sort of, 2 or 3 page agreements that set out the terms and conditions of the remote work arrangement and describes when the employer can end the arrangement. So that's another great idea. If you have concerns about a particular employee working remotely, you want to make it abundantly clear to them what the conditions of that arrangement is. You can certainly have them sign on to a remote work agreement. And finally, if you want to end a remote work arrangement, but you don't have a contractual right to do so in the employment agreement or in a remote work agreement, we have to think really strategically about how to recall the employee back to work. So in order to avoid a constructive dismissal, what we need to do is basically provide the employee with a new employment agreement that requires them to work in person, and we have to provide the employee with consideration. So it's basically like a pay raise or a signing bonus in exchange for the new employment agreement, or provide them with working notice of the change. So those are sort of tricky situations to navigate, and I would really encourage you to speak with your consultant at H2R or to loop us in if you want to have those conversations, because in order to avoid a constructive dismissal claim, we want to be careful about providing that consideration or appropriate working notice. So that's it in terms of my presentation. We sort of flew through that quickly, so I'm happy to stick on and answer any questions. And if there's anything that I can't answer right now, I'm happy to sort of take it away, review it, and then get back to Maja, and she can distribute my response.
Excellent. So does anyone have any questions? Feel free to put them in the chat box or Q&A. We will get back to one of the participants who had a question about the medical leave. So Catherine and I will touch base, and then I can let you know what the answer is. But thank you, Catherine. I did have a question. So it's either consideration in that last bit, or working notice? It doesn't have to be both?
No, it's one or the other.
Okay.
Working notice is a tricky one because it has to be working notice of termination. So
Okay.
that's like obviously pretty hard for a lot of employers to stomach, right? So you basically would say to the employee, hey, we're requiring you to return to work in person on X date pursuant to the terms of this new contract. And if you don't sign on to this new contract, your employment is going to terminate. And you have to make that really clear. So we find for that reason, obviously for workforce planning reasons, and we want to, avoid sort of those stressful interactions, that a lot of employers opt to provide the consideration instead of working notice.
Okay. Okay, makes sense. We did have another question come through for you. If an employee's remote work arrangement is coming to an end, how to communicate with the employee about it before giving them the new employment agreement? How much time should be invested in communicating this to the employee in the right way?
So that's a really good question. And I think it depends on the circumstances. So if the employee, like if it's known to them that the remote work arrangement is going to be a temporary thing and that's in their contract, they've signed on to a remote work agreement, I think you can just sort of send them the email or the letter saying, hey, per your agreement, your remote work is ending on X date. But if there's no sort of clear understanding of when the remote work arrangement will end, that's when we need to provide the consideration or working notice. And the working notice, in order for us to avoid a constructive dismissal claim, it needs to line up with the employee's entitlements under their employment agreement. And if this kind of ties back to the Dupo case, if their employment agreement is unenforceable, it means that we need to provide them with basically common law notice. So that's why it can be a little bit tricky. And I would recommend that you loop in an employment lawyer because we'll want to take a look at what are the communications surrounding the remote work arrangement, what contracts do we have in place? And if there's nothing, we're going to be looking at how much notice do we need to provide in order to lawfully implement this change without a risk of constructive dismissal.
Okay. And how many weeks is it, the common law notice?
So common law, there used to be a saying that it was generally 1 month per year of service. That has sort of kind of gone out of vogue because honestly, it can be more than a month per service. The factors that a court will look at in determining the length of the notice period is the employee's age, their length of service, the nature of their employment, and the availability of other employment. So obviously, if you have a really long service and older employee, we're going to have to give them a lot more notice than somebody who's only been with the company for a short period of time and who is younger.
Okay. Okay, excellent. Thank you. Hope that answers that question. All right, so thanks, Catherine. I'll be in touch with you later. I would like to welcome Reema right now. Reema will be speaking to us about benefits, so take it away.
All right, well, thanks for having me today. My name is Reema. I am a partner at Deverell Common Associates. We are one of the largest group benefits brokers in Southwestern Ontario. So we do help implement and manage benefits plans from groups of 2 members all the way to hundreds of members. And we're finding a lot of changes coming through in the group benefits world in terms of expectations from both employees and employers, and the value of having a plan in place and making sure that plan is always up to date. And so for today's discussion, to keep it light and on time, we are going to talk about the importance of partnering with the right benefit provider and what that means from an employer and an employee perspective. So let's start off by talking about the stats. So these stats are from 2023. We don't have 2024s yet, but you could see a massive shift in the importance of having a progressive health and dental plan for companies and members. So as of 2023, 72% of Canadians basically stated that they would prefer a benefits package and a comprehensive one at that versus getting a bonus on a yearly basis. And that goes to say they are also more likely to stay with the company having that package in place over taking a higher salary at somewhere else. One of the biggest shifts we're also seeing is the shift in needing benefits from a family perspective and a family planning perspective. So especially since COVID, we've seen this influx in addressing mental health, addressing physical health. So 1 in 5 employees will experience a mental health crisis, as we call it, which actually results in them taking time off work. So a lot of the conversations we're having these days is how can we help our employees kind of mitigate this risk here? And then just from a planning perspective, when we talk about financing and the cost of living these days, an average 30-year-old healthy individual saves roughly $1,000 a year on regular prescriptions just by having them through a benefit plan at work. And then there's a savings of 30 to 50% for an individual, again, the 30-year-old, in terms of dental cost savings versus having to pay that out of pocket. So the stats are basically saying to us that having a benefits plan is more important than ever. And how do we make sure that that's working for the members and making sure that it's important to them? So from an overview perspective, again, the way in which people are thinking about benefits has changed drastically. If we look at even just 10 years ago, the idea of getting a group plan in place meant, okay, we reach out to a company, they put a benefits plan in place, we have standard coverage, and that's it. They kind of leave it. We come across companies on a regular basis that we ask them, when was the last time you reviewed your plan or made changes to make it more relevant? And oftentimes we get people saying the average is 7 years. So a company has not looked at their benefits plan, has not even looked through their booklet on an average of 7 years. So this is kind of that old way of thinking about benefits, that it's just a set it and it's done. But that world is changing, and the importance of partnering with the right broker or the right team is really, really going to make that shift in terms of figuring out what's important for you and your company. And if you're going to take anything out of today's conversation, it's this slide here and the importance of what the right partnership does for you as the employer or the employee even, because what this means is the right partner is going to make sure that your plan is up to date. They're negotiating your rates, whether that is from the time of implementing a brand new plan or when you get your annual renews. The number of companies that we sit and see that, their premiums are going up year after year and they think they have absolutely no control over that, it's quite shocking. And then eventually we sit down with them and they're like, we're paying 20% higher than when we took this plan out. And they think it is what it is, but the right partnership is going to make sure that that's not the case, because that's actually should not be the case, especially if the plan is working and you're updating the plan regularly. And customized plan designs, again, it's no longer that mentality of set it and it's done. The right partnership is going to make sure that plan is relevant, whether that means you're updating certain features on a regular basis to make sure they're accompanying what is important in that plan. And the right brokerage service is going to find you that value, because what they're going to be doing on the back end of things is gauging what is being used and what isn't in your plan and making sure that members are getting that best experience out of it in order to get those comprehensive retention of employees. So, and then the ongoing service and plan maintenance is that big piece. And that goes beyond just the plan itself. This also comes in line with the members. We are finding that member satisfaction, should they have somebody to speak to when they do run into either a claims issue, an admin issue, really creates that satisfaction of having the plan and going back to the employer and ultimately being happy. We do find the biggest factor that deters a plan from wanting to renew or canceling their plan or putting a plan in place at this point in time is that sudden surprise. Because of the cost of healthcare these days, because of the demand of people needing more services such as mental health and family planning and things like that, we are seeing massive jumps in experience on that regular basis. And if you don't have the right partnership with somebody who's going to communicate these things with you throughout the year, and rather than just giving you, hey, here's your renewal of 20% this year, that's not a surprise a business owner should have. You have enough on your plate. So the right partner is going to make sure we're going to eliminate those surprises by the communication, by the monitoring of the plan on that back end side of things, and engaging with yourself and the team on a regular basis. Whereas we find that old way is just, it's not working anymore. Of the, you don't know who your broker is, you don't know what your renewal is until that renewal hits and you get the surprise. So we're kind of shifting away from that. So the importance of finding the right partner to work with for your companies is the number one takeaway these days, because that ultimately changes the experience for both the employer and the employee twofold. So if we could just go to the next slide there. Okay, so now this talks about what your role is in terms of what it means to find the right partner for you, because they could be different things that you're looking for. Whether you are a group of, again, 2 members or hundreds of members, I think your expectations should be the same in terms of who you're working with. So there's a few questions that we really feel are important to ask when you are looking for that broker. And there's a difference between assuming that you need to go to each company and get a quote versus finding the right broker to work with who's going to do all of that for you. So a couple big things. One of the biggest questions to ask is, what can you expect when you broker the plan? Because every broker is going to do things a little different. Some work through an automated service, which is going to automatically generate rates. This can have pros and cons. One of the cons being that if they do that through that third party, that broker's ability to negotiate comes down significantly. So asking what you can expect in terms of that negotiation piece is a big one if they are going out and doing it manually themselves. What does the implementation process? A lot of companies are finding that they don't want to be doing the implementation process because it could be a little lengthy in terms of putting a new benefits package together. So understanding what your broker's role is in that and how hands-on they are in that, because that will vary from brokerage to brokerage drastically. Now, some companies are completely digital, some are not, but you want to make sure your broker has some kind of role in that versus just handing it off and telling you to do it. So that's a great question to ask as well. And then what can you expect when the plan is set up? And this is kind of that ongoing service piece and saying, okay, now that the plan is done, is that it? So the right broker is going to give you options of services and ongoing service to expect, such as welcome seminars, helping employees enroll in terms of making claims, answering questions, being a contact person. A lot of brokers in the old way of kind of doing things, they would only work directly with the business owner or the company itself and not from the member experience. But the right partnership is going to take that off the employer and say, okay, send the employees our way. We will help with that implementation process, because this is now a service piece that should be coming off the employer side of things. So what does that look like with the brokerage you're working at? And then the ongoing management. You want to make sure it's benefiting both the employer and the employee. So again, that comes back to that big surprise that we don't want, an employer does not want come renewal time. And this is what that ongoing piece is. So by asking this question, you're basically getting that broker to talk to you about what their service is behind the scenes. Just because your broker is not reaching out to you every month does not mean they shouldn't be reviewing your plan. Whether that's from an experience piece, a claims piece, whether that is from a member experience piece, there should be some form of touch base on a regular basis behind the scenes to know that your broker is putting in the work to make sure this plan is going to be efficient come renewal time and thereafter. And then what if the plan doesn't work for us? Again, this goes back to that old school way of thinking that it's kind of a said and done. This is not the case anymore. Come renewal, if something is not working, the right broker is going to come to you with recommendations. They're going to come to you and say, okay, we have an issue here. Let's talk about how to kind of control this here. whether that's from the implementation piece, the renewal piece, or that means, changing things altogether. It's not a one size fits all, nor is it it's an evolving piece. And then what is the renewal process? So what can the employer expect at renewal time in terms of meetings, engagements, negotiations is a big piece rather than you just getting your renewal in the mail or an email and moving on. So these are the questions that when you are interviewing a broker, which we highly recommend you do, these are some of the questions that you should ask in terms of setting up the right milestones to kind of hit for your employees moving forward. And then we'll kind of talk about why these are important. Okay, so that kind of piece of reviewing the plan and making sure that right broker is going to be doing this for you. One is you want to make sure it's being used in the right way. You can have 80% using certain features of the plan, and then the rest is not being touched. Is that necessarily, would I say that's an efficient plan? Yes. But what if it's the opposite? How do you make sure your employees are getting the best way out of it? And then the member experience. You want to make sure, again, these are huge ways to retain employees. The stats are there for a reason. And you want to make sure that it's catering to that, and the right broker is going to do that. And then the benefits of requoting. So like we talked about, what is that renewal piece? So the option of requoting and negotiating rates. The right broker is going to get you an average annual savings of 7 to 11% just by taking that extra step. So that significantly adds up if you have a benefit plan for 20 people and you've had this plan for 5 years. Okay, services of a good brokerage. So these are things that a lot of people that we sit down with are surprised even happens. You want to make sure that they have more than one team. So this is going to be a good sign of a brokerage. It's not necessarily to say that standalone teams are not great, but having more than one person means a diversification of things that they can offer you, whether that's the member experience, the webinars, all that good stuff. And then back-end claim reviews. Again, I can't stress how important this is to make sure that your broker is doing these. We did have a case recently where one of their members got a serious illness and their claims skyrocketed. Like I'm talking in like 3 months, they increased by 210% in a 3-month window. So by knowing that, by doing our work on the back end, we were able to be proactive and reach out to the employer and say, okay, we need to look at options to make sure this person has the right coverage to battle whatever they are battling without it hurting the rest of the plan. Whereas if your broker is not involved on that back end side, they would not know that. And that surprise come the renewal time wouldn't have been a good conversation to have. And then that member experience assistance, again, that portion of whether that's the online apps, whether that's touching base with them, you want to make sure that that's a service that your brokerage is providing. Administrative assistance. So most online platforms now, from the employer perspective, you have the tools to add, remove employees, do the online administration, but you want to make sure that brokerage always has at least backup administration, just in the case that you need assistance somewhere. You're super busy and you can't get to something. You want to know that you could trust your team to do that. And then seminars, learning grows, welcome sessions, these are on the rise. Whether we're doing these on a biannual basis, whether we're doing these once a plan is set up, a good brokerage is going to be able to offer these services to talk about not just the plan itself, but how to benefit from a health perspective, whether that's talking about finances, mental health, how to get services, whether that's talking about the plan itself. There's a whole selection of them. And we are finding more and more, especially with the younger demographic of employees that are coming out, these are proving to be very, very successful. And the feedback has been absolutely wonderful. So we actually have members asking for them now more than employers, which is absolutely awesome. And then it comes back to that feedback portion where a good brokerage is also going to get feedback not just from the employer, but they're not going to shy away from getting it from the members as well. So whether that means through anonymous surveys where members can be absolutely transparent and say what they like, what they don't like, and then that broker can kind of take this back to the employer and say, okay, how can we adjust the plan? Because this is what your employees want. And then the reporting. So this is that piece of, coming to you with the numbers to say, okay, if we have a 20% renewal, let's talk about where it's coming from, and let's draw conclusions from there. So that's kind of the overview of the importance of partnership with the right benefits broker. I didn't want to go into the details of breaking down the benefits and things like that, because we could sit here for hours and hours. So I'm going to open it up for questions if anybody has any, or any experiences that you do want to talk about. Again, this is one of those things that if you do come across a plan that has been in place for some time, I really, really kind of recommend that you just look at it, reach out to a broker, whether you have a broker or you want a second pair of eyes. It's really important from a savings perspective and from that experience perspective.
Amazing. Thank you, Reema. And we actually work with Reema and her team when our clients want to shop the market for some possible savings on their plans. So if you're interested in exploring, please reach out. We'd be happy to partner with you. So I don't see any questions coming through. But yeah, if something comes up, I'll reach out to you, Reema, and appreciate you sharing all this knowledge with us.
You.
All right, so finishing things off with just a reminder. So next slide, please. We are hosting another workshop. This one is intended for leaders, and it's called Unlock the Power of Emotional Intelligence. It's facilitated by Shelley Brown and Jenny Simpson. They are our senior learning and development consultants. And Brad, can I ask you to share with us how this workshop came about?
Yeah, thanks for letting me join and talk a little bit about this workshop that we're really excited about. So, as with most cases, this stemmed from facilitating for some clients. And through feedback, we really saw an opportunity and a huge value add to organizations. And then the conversation steered into, we've got quite a few small and medium-sized businesses that may not be able to run a workshop internally. But still things like psychological safety, emotional intelligence, and overall leadership development matter to those organizations. And so through those conversations, we decided to shift and offer it as a public workshop to anybody who's interested. And it dives deep into emotional intelligence through really great conversation. So in terms of workshops that you might have attended, it's definitely more of a facilitated conversational workshop that you get to be a part of. And for me, those are my favorite ones to participate in. It is founded off of MBTI's assessments, which will be part of the course if you choose to join it. Is the science and backing of the workshop. So really excited to be able to share. We definitely have more details. So if you want to inquire and get a better understanding of exactly what's covered, I'm always happy to meet and have a conversation in that regard. And the last piece I'd like to point out is if you do have people leaders, so those with direct reports, typically this type of course would be covered under the COJG grant for training by the government. So you could also get some subsidy to cover some of the costs for the course, pending they have direct reports. That would be one of the criteria that need to be met for the grant for the course. But overall, very excited. Again, we facilitated this for a couple clients and the feedback was just over the top, positive, and we're excited to be able to bring it to everybody, even those organizations that may not have a large enough leadership team to facilitate this in-house. Again, this would allow you to join. Other than that, thanks for allowing me to join. I appreciate it. And
of course.
good to see everyone.
All right. So, yeah, and just to mention, it's a full day starting at 9 until 3. There will be a catered lunch. So if you're interested, either email Brad or myself, or to register, you can email info@yourh2r.com. And that is it. That concludes our Lunch and Learn for April. It was nice to have our speakers join, learn a lot from them, and everyone gets 10 minutes back in their busy schedules, and we'll see you next month. Bye, everyone.